Hello, good afternoon, friends. I'm so excited this afternoon. I am over the moon. I'm so happy. We just got a big win at the firm. A client's case has been approved, and we called her and she wept on the phone. We're so excited. I'm just so excited for her. So we're going to be discussing, of course, what happened, the journey, just everything about the case, the denial that she had received. I think it was an RFE that she had received, but she was heading towards a big denial. So it's an I-130 application. That's the first part of the application. And the client, welcome people. I hope I welcomed you guys. We're celebrating this big win. So drop me a comment and then I'll read it soon. I have a meeting very shortly, so I have to run off very soon. So the client filed for her father. And the client was born out of wedlock. So this client is a U.S. citizen. Okay, and she was born out of wedlock. This means that her parents were not married at the time she was born. And when your parents are not married at the time you were born and you're trying to file for your father, there's a number of issues. It's quite difficult. So she filed for her father. Her mother was, in her early 20s when she gave birth to her. Her father was also in his early 20s. They were not married. And when she filed, there were three issues that were raised. Three big issues. The first issue was that she has to prove legitimation. Either she's proving legitimation or, how did they put it, that she was born in wedlock, or that a bona fide father-child relationship existed prior to my client celebrating her 21st birthday. The second issue that the U.S. government, that's the U.S.CIS, which is responsible for adjudicating these immigration petitions raised. The second issue they raised was the issue of establishing paternity. That number two, she had to establish paternity. And then thirdly, she had to establish that, the different names that her father had used refer to one and the same person. So, oh my gosh, we're so excited. The issues were very big issues, because normally with RFE, sometimes you may receive one issue, sometimes two, but we had three huge giants and hurdles to jump over. And we started working and she had to contact her family back home. It was very tough, and then I was there last month and the client called me. She was exhausted because some of the places where she was trying to get her documents, there were just so many issues. She couldn't retrieve the documents. And she told me that, Akua, let's just stop. I know I've paid you all your legal fees. Don't submit anything. Let's just stop. This will not work. I don't want to go ahead with it anymore, because the client, she was really exhausted. And I know each time we tried to surmount a hurdle, there was a bigger one. So I emailed her, it was her prerogative. She had to decide. I emailed her the next day and I told her, well, she's decided that she doesn't want to submit anymore. So that's fine. We won't submit. And then after a few days, I decided that, I don't think we should give up on it. Let's just try. I'm going to use what I have, even though, because I was expecting her to get more evidence, but it didn't come. The DNA test that we had made her do, also the embassy back home where her father is based, they haven't been doing DNA tests for a while. So she had complied with her part of the test, the DDC diagnostics. She had sent her swab, and they need to forward, the sample to the U.S. embassy where her father is based has to do the test, call her father for a test to do the DNA sample. And then they'll, do the testing and then match it. But DNA samples, they've stopped it. So, it just looked dead. This case looked dead, but I still, we put everything together. My team and I, we drafted it. I drafted a 12-page legal brief. Oh my gosh, my arguments. Like, I started one by one. I attacked each element on its on matters of law or matters of fact. I explained, I over-explained, I elaborated, and then I tied everything together. And I'm just so excited that the case has been approved because, I mean, the issues of legitimation, I had to use, case laws in Ghana discussing how in Ghana, there's no illegitimate child. There's no distinction between legitimate and illegitimate children. According to the Children's Act 98, there's no distinction. And in fact, prior to the Children's Act, there was even no distinction anyway. So I had to discuss all of that when the client was born, when her birth certificate was issued, and then come out with the legal analysis, that she was not an illegitimate child. And so she had proven that she was legitimated before she turned 21. We went on to the second one, establishing paternity. We used the matter of Rahman, where there's a delayed birth certificate. And in this case, the client had even she had a delayed birth certificate. Her birth certificate was procured when she was 24 years old. And normally when your birth certificate is that old, it raises issues of fraud and fraud and all of that. So that was another hurdle because she had it at 24 years old. That was when her birth certificate was made or whatever. Big issue. I had to argue on all those grounds, and the final one was, the name issue. I quoted BBC articles. I went to look for articles, African articles, names of Africans, oh my gosh, how sometimes Francophones will spell a name in a certain way and Anglophones would spell a name in a certain way, something like Kwame, where Francophones would probably say Kouami and Ghanaians would say Kwam. Use my own name in the argument along with case laws. Let me read a portion of this case law to you guys. I found this case that was very interesting and that had to do with name, differences in names. So let me just read this very, very interesting portion to you guys. So let me see, right here. Yeah, hold on, guys. At some point, I even say, in fact, the writer of this brief has the first name of Akua, Akua, which is for females born on Wednesday. However, there are variations for this, and it could be Akua, Ekua, Kuu, Kua. I gave all these things, and I said all these names are viewed as one and the same. Then I put links there. Kindly read more on this here. I gave certain quotes or whatever, and then the case law. To add to the above, guys, follow me. To add to the above on the issue of similarity of names, the case of Chang Yang Chu versus Boyd established an interesting principle, which, though not exactly on point with the issue at hand, may help in resolving it. This case stated, when documentary evidence bears a name identical to that of the respondent, an immigration judge may reasonably infer that such evidence relates to the respondents in the absence of evidence that it does not relate to him or her. Okay, so I think in that case, this has been, I did some weeks ago, so I've forgotten the specific facts of the case, but the appellant urged that there was no proof of his identity with a person who was convicted of and sentenced for a bank robbery, saying that it wasn't him. Okay, so there was a bank robbery, and then the person was like, oh, it wasn't me. There's no proof of identity. And then the case law says that, in fact, there's much proof. The documentary evidence shows that the man with the somewhat unusual name of John Richard Bayless, who was convicted and sentenced in California in 1952, had been a prisoner bearing that name for a few months. It goes on and on and on and on. Then the judge says, nothing short of a fantastic cloak and dagger operation engaged in for no conceivable reason could have separated this person from that name. The trial court was correct in not indulging in such fantasy. This court has held that identity of a name is sufficient to establish the identity of the person in the absence of contrary evidence. Okay, so I went on and then I concluded that, look, the unusual names, and then I gave the client's father's unusual names, the two names that he uses, refer to one and the same person in the absence of contrary evidence. I'm just so excited. We're just going over this case when what happened. And then in my final matters, I concluded and said that for the purposes of emphasis, the petitioner wanted to draw the attention that she had complied voluntarily with the DNA test results, and that she should not be punished for the sins of COVID-19. The embassy is closed beyond her control, and that we ask that the case be held in abeyance while the DNA sample for her father be collected, because her mother had passed away, and that they should not deprive her of the opportunity to reconcile with her only parent alive, based on something that is out of her control, So all those arguments, of course, I discussed the standard of evidence, that the preponderance of evidence was the exact standard that was needed in this case to establish paternity. And what does the preponderance of the evidence mean? That this is probably true. And I, discussed case law, I discussed statutes, I discussed the facts of the case, tied it again together, emphasized, concluded, and showed them that, look, even without the DNA, we had demonstrated fully that she was indeed the child of the father, and the daughter of her father, and she was entitled to the immigration benefit that she was seeking. I'm so excited. The client, this is a changed life. Her father, she told me her father told her, "Why are you worrying yourself? Let's stop this. This is getting too much. It won't work." And I had the client on the phone, and she just wept. She wept. She's just so happy. And this brings me so much joy. So I wanted to share this wonderful news with you guys. Just celebrating the big win here. I'm just so thankful. So I haven't even read comments, guys. You can see how excited I am. So we have Mami Koraba says, "Hello, AK." Hello, Mami. I hope you're doing well. We have Bernice Agbenowo says, "Hi." Hello, Bernice. So guys, that was just a quick one. I have to rush off. I have a meeting now. So I'm going to get ready and prepared. So I'll see you guys in the next video. Don't forget to call me on 802-7800-564, and I will be here to help you live your American dream. I represent clients in all 50 states, and I represent immigrants in all immigration matters. I'll see you guys tomorrow. Please take care and be safe. Bye.